My Lord, can I just hold a hand up, please? I've spoken to Mr. Reedy, the 3 documents that you requested this morning. So we've got the confidential, an extract from the confidential part of the witness statement of Mr. Babcock, together with the order. There's the disposal plan, which my Lord asked for, and the relevant paragraphs of that are paragraph 3.1 through to 3.5.
Yes.
So disposal, I'm not sure which order you've got them in, but this document looks like this. This was approved, obviously, by the Secretary of State. And then the indicative valuation that my Lord asked about is at paragraph 3.1 through 3.5, which is at the back, the last 2 pages.
Yeah.
The extract of Babcock, Mr. Babcock's statement doesn't need any more elaboration. And then in relation to my Lord's request for the Welsh asbestos case, I provided that judgment. And it's particularly paragraphs 50, 51, 52, 53 of Lord Mance's judgment.
Thank you very much. Yes, Sir James.
I was just before I forget, in relation to the asbestos case, I don't think I'm going to have to do the usual chasing down of the cases which followed asbestos, but my Lord may well recall that those passages and the way that proportionality is approached under the 4-stage test, and whether each of them attracts margin or doesn't attract margin, was the subject of repeated subsequent consideration by the Supreme Court, culminating, I think, if I have the memory right, in Lord Wilson saying let there be no more doubt about it. And the no more doubt about it was that this was not the law, and that margin of appreciation applies at all 4 stages, including the final fair balance stage of the proportionality exercise. I suspect the best way of putting my Lords into that particular principled picture is to provide you with a judgment we haven't seen necessary to provide you with so far, but it does, amongst other things, consider deprivation versus control of use and that line of case law, but it also considers this specific point, because Mr. Birdling, for the claimant in that case, was running exactly that argument. Look at the way in which Lord Mance did it in this case. We went through all the cases as the Court of Appeal does. I think it's Lord Justice Newey goes through the various cases that lead up to Lord Wilson saying let there be no more doubt about it. So perhaps if we provide that case to you electronically, if we may, and highlight the relevant passages, and that will mean I don't have to go through that subsequent exercise of tracing through the case law.
Yes.
Can I leave that way?
Certainly.
I wanted to start with 2 or 3 preliminary points in response to my learned friend's submissions, and then I'm going to divide my submissions broadly into 2 parts. One of them is to do with deprivation versus control of use, what is the right principled approach to that, and then secondly, compensation and how that all fits together. So the 3 or 4 or 3 preliminary points. First of all, timings. Again, there's been quite a lot of discussion about how the timings all work together in relevant parts, and it may be thought to be particularly relevant to an issue which we'll obviously have to come back to, which is related to assumption of risk. But the relevant timings, and I'll, by way of a sidewind, as it were, answer the question that my Lord posed about what the date in section 2.4 of the Act meant. But that's the starting point in my submission, because the date that was referred to in section 2.4, as you will recall, was 12/11/20. So it was the 12th of November 2020, and my Lord, Lord Justice Singh correctly appreciated in my respectful submission that the reason for that was the usual anti-avoidance one that one finds very often in, for example, tax legislation. So the moment the intention to legislate is out there, countermeasures can be taken, and it's designed to avoid that feature that Parliament introduces that element of retrospectivity, as it were, if that's the right way of looking at it. So that was the date, 12/11/20 in section 2.4, and it is, unsurprisingly, no coincidence that the date on which the bill received its first parliamentary reading was the 11th, so the day before, and that's absolutely common, as my Lord has noted. So from that date, everyone is well alive to the fact, or can be taken to be well alive to the fact, not merely that legislation is a remote possibility, but that the government intended to invite Parliament to legislate, because the bill receives its first reading in November. And no doubt it was in part that which triggered, under a month later, the attempt to engage with the Bay's officials. Do you remember that was referred to in the judgment at paragraphs 44 to 46, that engagement process? And that occurred on the 9th of December 2020, so that's the next relevant date for that purpose. We then know from the judgment at paragraph 35 that the investment was initially made into what became UP in January 2021. At that stage, as the judgment records, was simply the purchase of the company or the shareholding of the company for £100. So that's judgment paragraph 35. So that investment is made, in effect, 2 months after, but over 2 months after the first reading of the bill in Parliament, and about a month after the engagement which doesn't result in the comfort that they were seeking. So that's the position at that point. The Act is then assented to by the Sovereign on the 29th of April of 2021, so 3 months later. And what we don't have from the judgment is the dates on which the various investments were then made by these individuals, but that is not perhaps for present purposes. The process of enactment culminated at the end of April of 2021, and it was then commenced, again you get this from judgment paragraph 7, quite a significant time thereafter in January 2022. So one can see just from those timings the way in which the investment, the engagement mapped as against the legislative process and the appreciation or otherwise of what the government intended and Parliament ultimately did. So that's timings. I wanted to turn secondly to the nature of the national security case and the findings made by the judge, and I'll take this relatively briefly. If you have the judgment to hand, I don't know whether you have that loose, it's in the core bundle starting at page 100. I just wanted to trace through the key paragraphs. I'm sure this won't be the totality of them. I'm sure the court has carefully read the judgment in more detail than I'm going to take you to now. But you will see, if you pick it up at page 110, paragraph 40, that the UBOs in this case were sanctioned. And they were sanctioned both at the European level and in March 2022, post the invasion of Ukraine by Russia, they were sanctioned under the 2018 regulations, which I know my Lord is very, very familiar with. So that was the sanctioning. As we know, there was a hiatus, as it were, as you see from paragraph 41, in relation to the EU sanctions position, but only in relation to a set period. Those sanctions then resumed. So you've got UBOs sanctioned both under the Russian legislation as a matter of UK law and under EU legislation, which is one of some indication of the national security position. 63 of the judgment, para 63, the judge sets out the nature, as it were, in open of the national security concern in the letter that is there quoted from, as you see. And then that is then retouched on by the judge at paragraph 74 when dealing with the ministerial submission, the final document that went to the Secretary of State before the decision. And of course, one of the things that was being considered in that decision-making was whether or not remedy B, as it was called, called primarily contended for by my learned friend as being the less intrusive measures below, whether those would be sufficient. And they analysed the national security position from that perspective, as you see at paragraph 74. Then at paragraph 83, one sees the reference to the ISRA summarising the risk to national security in the terms that you see. And then you'll see in the judge's findings in relation to national security, the section starting at 110 on page 125, under the heading, the framing of national security risk. You'll see the nature of the submission that was made about the national security risk by Mr. Hickman at paragraph 111. And you'll see the judge's acceptance of the submission on national security made by Mr. Phillips below at 112. Can I just invite you to cast an eye over 112 or remind yourselves of the judge's findings on 112? And the first thing perhaps to say that follows on from that is that the assessment of a national security risk of the kind that you've seen described evidently does not turn and cannot sensibly be taken as turning on the distinction, as it were, which Mr. Hickman was keen to emphasise this morning, between corporate and shareholder risk. National security looks at both and would have to look at both, because there is always the possibility that the shareholders will ultimately control what the vehicle company does.
Presumably it's that kind of rationale which lies behind the legislative provisions about the trigger events.
Oh, yes, it's precisely that. They're structured in terms of control of entities or corporate bodies, exactly so. But it's unsurprising, as a matter of generality in relation to national security risk, you don't need me to tell you, the state couldn't possibly say, well, here's a strict distinction in company law between a company and its shareholders. Of course, that's right legally. National security terms, that's pretty much irrelevant. What matters is the reality. Where does the risk flow from? What is the nature of the risk? And indeed, that point about corporate structure was specifically returned to by the judge. You go forward to paragraph 206. You will see that the judge made a specific finding about that very distinction, which was being urged upon her below. And I wanted just to make one thing clear as well. I think my learned friend might have submitted this morning, I'm entirely sure we might have submitted, but the judge doesn't say she relied on anything enclosed in relation to national security risk. If you go to the very last paragraph of the judgment, it's evident that the conclusions that she reached were supported by the closed material, and she's got a separate, she's produced, or did produce, I think the court has it, doesn't matter, but she has produced a separate closed judgment dealing with those matters. Now, of course, this is an appeal in open, and it's an appeal on the points of principle that we've been discussing, that skeletons are addressing, but the judge evidently did see and rely upon the closed material. And obviously, the closed material will deal with, it will have by definition to deal with, matters that are relevant to national security. I say it will have by definition to do that because you'll know that the closed material process is fundamentally premised on that under the Justice and Security Act 2013. has to be relevant to national security to enable a court to go into closed in the first place. So that is the position in relation to national security, because it doesn't directly answer the question I know my Lord Justice Popplewell was interested in, which is, well, where on the potential spectrum does the case lie? But I've said what I'm able to say by reference to the judgment in open on that subject, and I am entitled at the very least to pray and aid the fact that the judge considered those matters and considered that they supported my conclusions when the closed material was taken into account. So that's all I want to say on national security. Lord Justice Popplewell is my third area. Lord Justice Popplewell...
Sorry, just before you move
Yes,
on.
I'm so sorry, my Lord.
The judge said that proportionality was a question for her to address.
Yes.
And for reasons which I don't think we ought to be concerned with, it's been decided that this appeal should be determined on the basis of the material which is in open, not in closed, and that we should not see the closed material in order to inform our decision. And does that then mean that we are really confined to what the judge identified in her judgment by way of national security, as opposed to saying, well, she may have seen a lot more?
Well, my Lord, from our perspective, we hadn't felt it necessary for the purpose of the appeal to date to put that in. Of course, we fully recognise that a court sometimes gets interested in aspects of the closed material during the course of the hearing, and it sees things that it might be interested in seeing from the close. And from our perspective, there would be no objection at all if the court wished to see it in the court being provided with the closed judgment. It might be the
Would that then require special advocates to be instructed? Because I'm not sure that basic fairness can be complied with if we see material which the appellant doesn't see.
Well, I've certainly had one case recently in which the court, exactly this happened, and the court was provided with the closed material, and I think the special advocates were notified that that had been done for information so the court could look at it.
Can we leave it like this? Shall we see how we get on?
Yeah.
So, certainly for my part, I have been content and remain content
To address it in open.
to address it in open. I've borne in mind, since my early reading about this case a few weeks ago, what you said in footnote 4 of your skeleton argument, that it was not going to be necessary to have a look at closed material. So that's how I would like to proceed. But if during the course either of arguments or after the hearing is finished in discussion amongst the judges, we feel that it is going to be necessary for us to have a look at it, we may need to revisit that.
My Lord, of course.
It's not at the moment, at least as I see it, a case of the court asking to see closed material, but rather the question is, if the parties don't choose to put closed material before us, what can we do other than decide the case on the basis of what is in open?
My Lord, I totally understand that, but again, judgments are made at the stage of preparing the appeal on both sides as to whether or not that would be a useful thing to have.
I'm not criticising the decision
No.
that's made at all. I'm just saying this is
where you are.
we appear to be.
Yeah, my Lord, yes. And my only invitation is not positively to invite you to do it, but because we think we have enough in relation to national security on the face of the open judgment, with the reliance on closed, to the extent that's relevant, and it's very unlikely, given the nature of the issue that is before you, that precise degrees and content of the national security case are going to tip things. But if the court does think that's interesting, as I say, we remain open and ready to help, and we may have to work out a process if that is done. As I say, I think in the previous case I did in which that had happened, we gave notice to the special advocates in the end. There was no need for them to make any submissions, because the matter was just, the closed judgment was being provided to the court to give them the broader context.
Yeah. Right.
The third preliminary matter I wanted to deal with related to a question I think Lord Justice Popplewell was exploring with my learned friend in relation to whether or not, if geopolitical change happened, what was the extent of the ability to reopen, as it were. And I think we're in agreement about that. If the Secretary of State is given clearance and then wants to recall it in the future because of developments, there would have to be a trigger event. So there would have to be an acquisition or a change of influence or something of the kind that you see set out in sections 8 and 9 of the legislative scheme. But it's right to note that the schedule can be changed. The Act is, as it were, universal. the schedule sets out those cases in which there is a mandatory notification regime. So you have to notify in advance if you fall within the subject matter area. But of course, those regulations can be changed or can be broadened by secondary legislation. And the Secretary of State, if there is a trigger event, is not restricted to looking at matters that are listed in that, that set of regulations. So if there is a trigger event, but there would have to be, if there is one, the matter can go back to be reconsidered by the Secretary of State in effect at large to take into account developments in geopolitical matters, even if they may or may not fall within the specific categories identified in the regs, because they're serving a different purpose, which is to identify subject matter areas for mandatory notification. So that's the way I think the legislation works. If that,
because I was on a slightly different point. I wasn't concerned with re-examining the question. I was concerned with whether there might be circumstances in which a party might be reasonably in a position where they hadn't notified because they weren't within the regulations, and they hadn't reasonably anticipated that it was a case of voluntary notification, and without the regulations changing, nevertheless geopolitical circumstances could render them susceptible to the matter being called.
Yes, and again, I think we all agree about that. The answer to that is it can be taken into account, so that rather...
provided, of course, there's a trigger event. But
provided, of course, but on that assumption, there probably...
the notification requirements don't dovetail with the circumstances in which the Secretary of State can make...
The mandatory notification requirements, exactly. That's why I said the Act was universal in that sense. So if the trigger event's there and it's in, everything is fair game to be considered, as it were, as long as it's relevant. My Lords, can I then turn to control of use against deprivation? And I start perhaps with the obvious point, which is that under Article 1 of Protocol 1, these are, in essence, points on a spectrum, the spectrum being seriousness of interference. And again, that is a matter that has been much debated in this court and in other courts, whether, as it were, there is a critical category difference between the two. It may be of some relevance, we accept, but whether there is a critical category difference is an unfashionable theory. The better theory tends to be that they are points on the scale of seriousness in terms of the degree of interference. And that is reflected, it might be thought, particularly in the Supreme Court's judgment in Mott. I don't invite you to go back to it, but if you were to go back to it, one can see, particularly at paragraphs 32 to the end of the judgment, it's about a page at the end where Lord Conworth analyses the position. But the position is that even if something is a control of use, it can nevertheless be a control of use of such seriousness as to render the payment or non-payment of compensation relevant for the purpose of assessing the proportionality balance and unfair burden or unfair and excessive burden. And I suspect that it was in part that, or perhaps principally that led to the judge's conclusion, which you saw, which was that she considered she didn't need ultimately to resolve that issue because the proportionality of not having compensation was going to be the same. So the analysis of it was going to be the same in this case, and we respectfully submit that isn't a wrong conclusion necessarily, but there are certainly cases, it is right to note, there are certainly cases in which the courts have accepted that whilst not crucial to the compensation or not question, the deprivation versus control of use dichotomy may be relevant to proportionality. And one sees that, I'm going to come to it in a moment, but one sees that in particular from the Court of Appeal in British American Tobacco. I'll just give you the reference at this stage if I may. Lord Justice Lewison, paragraph 113 on the potential relevance to proportionality of that distinction. I'll call it that distinction in shorthand, with the caveat that I've already made the point that it's about spectrum of seriousness of interference. But we submit, if necessary, that this was correctly characterised as a control of use rather than a deprivation. And I wanted to start, if I may, with the principled approach and the principles. And the first of them is that the test for something falling within the deprivation category is a very high one. And I'm going to try and take most of this from the British American Tobacco Court of Appeal judgment, if I may, so it may be as well to get that up. It's behind tab 8. Not entirely sure where my Lord's dividing line lies in terms of the thing, but it may well be that's in your second.
Yes, it is.
On account of the thoroughness of the judgment of Mr. Justice Green at first instance in British American Tobacco. So tab 8, if I may, and really the paragraphs that you want for present purposes, just to see where we are in the judgment. If you start at page 643, you see a title at the bottom, 643, paragraph 91, A1P1, and there is then a section which really runs through, perhaps to the end of 115, in which they analyse this issue, the deprivation versus control of use. And the first proposition of principle is that the deprivation standard is a very high one, and it's reflected in the idea that the person should be deprived of all meaningful use of the property. And one sees that, one can take it from any number of cases. I think it originally started in a case called Frieden and Sweden, but you see that principle reflected in paragraph 96 of the Court of Appeal's judgment. One part of the test is whether the complainant has retained any meaningful use of the possession in question, and they cite Pine Valley and so on, but one could equally cite Frieden, which was the source of that principle. Second principle is that the correct approach is to focus, we submit, on the substance and reality of what occurred, not narrowly on the particular species of property right. And all of the Strasbourg case law indicates that that is the right approach. You don't just, one can call it atomizing, if you will, you don't just take a particular piece of property and say, well, if that's gone, it's gone, and that's the end of that. You look more broadly, you stand back with a broader focus and look at the broader picture in judging the reality and the substance of what's occurred. Has all of that property, in effect, gone? Has the state interfered to the point of deprivation so that there's nothing left of that property is the second principle. And part of that involves looking to see if the possession and its value have been taken away. And the examples of deprivation that has been, a case of where deprivation has been the characterisation, have in effect involved both. And especially so if the thing involves expropriation by the state. See, for example, paragraph 95 and the examples that are given in paragraph 95 of BAT, if I can just ask you to cast an eye down that. And I contrast that, you see the Greek case, I contrast that, as did the Court of Appeal when it came to paragraph 96, which we've just seen, with the cases in which some meaningful use of the possession in question is retained. And I'm looking at that concept broadly in the manner that I've described. You see one of the cases that are there cited as an example of that. In other words, where lots and lots have been taken away, but some bare thing remained, as it were. That's really what those cited cases in 96 are to do with. And And again, just a note next door to paragraph 96, I don't invite you to flick back in the authorities to it, but the facts of Pine Valley, for example, on the case is cited at paragraph 96, are dealt with in summary by Mr. Justice Green in his first instance judgment at paragraph 735 in the previous tab at page 504. And just to read you what he said about the facts, Pine Valley was a case in which there was no expropriation of property when planning permission had been revoked in relation to land which could have been farmed or leased and which was not rendered worthless. So a very, very significant interference with the value of the thing, but not rendered valueless. And where the value of something has reduced so that it isn't remotely what it was, is not enough to bring you within the deprivation or the expropriation category. And one sees that specifically dealt with in the application, in that case, of the principles. Look forward in the Court of Appeal, if you're still there, if you would, to paragraph 106, bottom of page 647. Tobacco appellants argue, no doubt rightly, that regulations may be far less valuable than they were before. Some residual utility is the principle that's applied. It's the flip side, if you will, of no meaningful use. So that's the second of the principles. The third of the principles that we respectfully recommend to the court is that the nature of the scheme is important. If it is a general scheme to control the use of property, then that is highly relevant to the characterisation as control of use or deprivation, even if, for example, the legal title to a possession is taken away, even if property is entirely confiscated and deprived, to use that word loosely, under that scheme. I'll come to examples of this in a minute. And even if the consequence of the interference is in fact to put the business out of business. And if you go back to British American Tobacco, paragraph 97, you will see that principle reflected. On the other side of the line, say the Court of Appeal, even where the complainant does lose its legal title to the possession in question, that loss does not necessarily amount to a deprivation as opposed to a control of use. And the Court of Appeal cites, Lord Justice Lewis and the Court of Appeal cites the various authorities that you see, including Agassi. And you'll recall that in Agassi, the complainant was the holder of the retention of title. So entirely innocent. But the coins had been smuggled, the smuggling regime and the consequences of it were a general scheme for the control of the use of property, allowing particular property to be confiscated, to be deprived. But nevertheless, that was held to be a control of use. And one can multiply those examples. Agassi isn't a one-off. Again, without wishing to go back to it unnecessarily, you might like to write next door to paragraph 97, see also, Mr. Justice Green, as he then was, 773, 773 in the previous tab. And the reason for giving you that reference is because there was, shortly after Agassi, a very similar case involving Air Canada, in which various breaches of a scheme had occurred and the planes themselves were confiscated. So again, you have an example of a scheme which is designed to regulate or to control the use of something, and in which the person is, in effect, entirely deprived of their property.
Well, only because they breach some condition attaching to the control. So if the primary regulatory scheme is control of use.
Yeah.
But that's supported at the enforcement level by taking away title. And it has to be.
Oh, yes.
Because otherwise you can just cock a snook at the state and say, well, I'm not complying with the control of use regulations.
Yeah.
So I can understand that line of authority. Mr. Hickman distinguishes that. He says that's not this kind of case. So far as J.A. Pye Oxford is concerned, again, it might be said that that's a very special kind of situation because it's to do with how, when you have a general reform relating to title in land, how do you deal with adverse possession and rights which have accrued in squatters through adverse possession? And the paragraph tells us how it was dealt with in the case of unregistered title and in the case of registered title.
Oh, yeah.
And one understands that.
There's a general scheme of use, and it leads to
Exactly.
something which might be called a deprivation.
But what? No doubt you'll help us in due course when you apply the principles to the present case. What we would be interested to know is what the control of use scheme is in the present case.
Yeah.
But on the face of it, it looks like deprivation.
My lord, I'll come to it, but my submission is going to be that the control of use is the scheme provided for in Parliament to make sure that shareholding is held subject to, albeit outlying, but subject to outlying public interest concerns and control. And in that respect, and viewed in that way, these are not terribly dissimilar from, for example, Argosy, because under Argosy, one can perfectly sensibly say, and I see entirely why my lord puts the point to me, well, Argosy is all about the enforcement regime that must underlie a scheme that is designed to control the use of particular properties. You don't smuggle it across borders or breach a rule. But ultimately, the court could perfectly happily have analysed those cases by saying, well, that's all very well, but it doesn't actually bear on the distinction that we're talking about here. They could easily have said, it is in fact a deprivation of possession, but it's a deprivation which is justified, and not merely is it justified, but it's a justification which does not require the payment of compensation because you breached the rule. So the fact that the distinction that my lord has identified exists, which I entirely accept, we submit, does not necessarily bear on the distinction which we're debating here. But as I say, when we come to apply it, my submission will be that actually we are pretty close to this. We're pretty close to this because this is a scheme in which the state says, by and large, you can hold property, you can own shares, you can set up companies and the corporate structures in any which way you like, complex or otherwise, but that ability to hold property is subject to certain rules. And the rules in question are that if it puts the public interest at risk, the state is entitled to require you to divest. Even if, viewing it narrowly, the divesting means you have to get rid of the shares. To some extent, it bounces back to the point I made earlier on about not atomizing and standing back and looking at it in the round. But that's how we would answer, my lord. I say some of these cases, which is no doubt why Mr. Justice Green's judgment was so thorough, but some of these cases are not entirely easy to reconcile in terms of the principles because they don't tend to grapple with what the principal distinctions are that underlie the different results on the cases. Some might say that's a virtue and not a vice because Strasbourg always looks at the particular facts, but I do submit that these cases do, and they're a well-recognised line of cases, Argosy, Air Canada and so on, these cases do stand for the proposition that what you don't do is just look at a thing and say, well, this particular bit of property has been taken away pursuant to that regime. It's relevant to stand back and look at the nature of the regime and say, is that a control of use of particular property? Even if the consequence of enforcement or its application are that a particular species of property, viewed narrowly, is taken away or is required to be divested. And one gets a similar sort of point from the last of the categories that I referred to earlier, which, again, my lords will no doubt well recall. Paragraph 98 gives you the examples, all from the United Kingdom. Pinnacle Meat, as you'll recall, was the cattle head deboning case, in which, in effect, as you see from paragraph 98 by the letter B in the Court of Appeal's judgment, the complainant was forced out of business and thus lost its goodwill. The Commission nevertheless treated the interference as a control of use. and one of the points made that was still open to the complainant to use its tangible assets in an alternative business. Well, again, that is no doubt true, but there's a limited market to specialist equipment that's used for the cattle head deboning process, one might think. In any event, one sees that putting someone out of business by, in effect, altering or revoking their licence in consequence of the public interest driving the need to change is characterised as a control of use and not a deprivation. And again, one sees the same sort of thing in relation to Ian Edgar. That was the ban on firearms following the Dunblane massacre. Again, control of use, not deprivation. And East Side Cheese, my only friend relies upon for the proposition, which we don't dispute, that in some cases it isn't calling something expropriation and linking that to the state that matters. That you can have a deprivation or even an expropriation, properly so called, in which the state compels someone to transfer it from one to the other. There undoubtedly are cases where reliance has been placed on the fact that it's the state that gets it. It's the state that gets the money, or the asset. But East Side Cheese, the reason it's cited here, I suspect, and the reason that I asked the court to read those subsequent paragraphs, 58 and 60, you don't need to go back to them, was because in that case, as you'll recall, what was required to be done was a destruction of the cheese. And so if one zoomed in and said, well, look at an asset, has an asset been deprived? If you destroy something, particularly if that thing is the tool of your business, if it's part of the broader scheme of control of use, then that is sufficient to bring it within the realm of control of use, even if certain property narrowly viewed is, in ordinary parlance, being taken away or is being destroyed in some cases.
In East Side Cheese, were they, in quotation marks, wrongdoers of some kind, or were they entirely innocent members of the public?
I can't remember, but the cheese was dangerous. The reason I can't remember whether the cheese was dangerous because of a failing or because it was just dangerous as a result of scientific development.
I mean, as a matter of principle,
yes.
I can envisage both kinds of scenarios.
Yes.
There may be public health reasons where even someone who's, in quotation marks, entirely innocent,
Quite.
you may well have to take drastic steps. But where you have the wrongdoer, if I can call them that, I mean, the courts are routinely in the position where they make things like forfeiture orders, destruction orders. I mean,
That's true.
Every Crown Court up and down the country
Well, that's undoubtedly true.
does that.
The question is whether that is the guiding and restrictive principle.
Right.
That's the question you're probing. And at least an answer to that is provided by paragraph 98 in my submission, because the people in Pinnacle Meat were not being subject to the thing that put them out of business because they were doing something particularly wrong. They were being put out of business because there had been a development in the science and people had worked out that mad cow disease existed and that new regulations were required in the public interest. And the same in relation to Ian Edgar. No doubt, none of the people who shot firearms in the Ian Edgar firearms salon were wrongdoers. The wrongdoing had been done by the person who was involved in the Dunblane massacre. As a result of that, Parliament changed the law, and that was the result. So it's really the twin urges: stand back and look at the scheme, but also stand back and look at the property. The correct approach is not to zoom in on a particular bit of property and say, where are you? Has that gone? Has that been deprived? The truth is you need to stand back under this case law and look to see what the reality and substance of it is, and ask the question, is all meaningful use gone? Has in effect their property been taken away? When you're dealing with something where you get something back, you get the value back and you can keep it. That's obviously a different situation to the situation in which the state simply takes something. That's the basic thesis. And I did want to go back to Lord Justice Green's judgment, if I may, just for one purpose, because there's a helpful, if long, summary of the various cases in Strasbourg, and I can perhaps most conveniently take it from here. You've got the judgment on UCOS in the raw, if you want it, behind tab 27. If you go back to tab 7, and you go to Mr. Justice Green's, he then was para 779.
Yeah.
The start of 772. 772 does a Gossi. Air Canada 773, we're on page 517, 518. You've just got a slightly fuller section from the European Court judgments in those cases, which might be helpful. Pinnacle Meek 774, I in Oxford 776. Jahn in Germany, which is to some extent a specialist case because it all arose out of German reunification and various removals of property that occurred in relation to that, held to be a control of use in the special circumstances of those cases. And then one comes to UCOS 779, and I'm sure the court will well recall the circumstances in UCOS, a company that was owned and controlled by a man called Mikhail Khodorkovsky, who decided that moving from making money in the oil and gas sector into the media sector in Russia was a good idea. As it turned out, it wasn't, because the first thing the Russian state did was then to impose a series of swinging tax demands, and the allegation in UCOS, ultimately upheld by the European Court in Strasbourg, was that that had been, in effect, a concerted state campaign to impose those liabilities on the company with a view to seizing it to the state's benefit. And again, you'll probably recall there were then, when that money couldn't be paid because of the scale of the tax demands that had been imposed, the state ultimately took, by way of enforcement in inverted commas, some 75 or over % of the shareholding in the controlling company in UCOS, and in effect took it over for the state. The purchaser in the auction, in inverted commas, turned out to be a Russian state company set up for the purpose. So those were the facts of UCOS. You see the judgment being cited by Mr. Justice Green at 779, and you'll see the tax assessments that were imposed halfway down para 555 in the quote, ordered to pay an overall sum of around 16 billion euros, with a whole series of additions onto that, including as enforcement fees and so on. And then when that couldn't be paid, its assets were attached and seized, and 76.79% of the shares in its main production unit, Ugans Kneftegas, were sold in satisfaction of the mentioned liability. And you see the allegation by the company recorded at 556. And as the court notes, even in those circumstances at 557, which is quoted in the judge's judgment at paragraph 780, notwithstanding the extreme effect upon the company, the court considered the facts reflected a control of use. And what at least that demonstrates, even on the extreme facts of that case, is that if the state takes over, in effect itself takes over a shareholding in purported enforcement proceedings, then that is or can be still a control of use and not a deprivation. Now, of course, my lord, the position could well be analysed on the basis that if you assume that everything that was done was genuine, this is in effect an enforcement mechanism, and then I have to make the analogue to our situation. But it is, of course, one accepts the genuineness of the tax demands and that they were entitled to get hold of the assets of the company for the purpose of satisfying that. It is in the nature of an enforcement regime and can be explained on that basis.
Is there somewhere in a skeleton argument or anywhere in writing where we can see neatly encapsulated how the respondent puts the nature of the control of use scheme? Because off the top of my head, and I don't want to put words in anyone's mouth, but I can see an argument that it is a control of use scheme, because it could be said that unlike, for example, some of the redistribution of wealth cases that we've been taken to, and unlike nationalisation cases, strictly speaking, when the iron and steel industry was nationalised, the banks may be nationalised, Northern Rock. Unlike that, here, might it be said that the government is not actually that interested in using, as it were, having the benefit of these assets or redistributing the assets. What it's concerned about is the risk to national security which in turn depends on who is the ultimate beneficial owner. In other words, what it's really getting at is we want to alter those who can own the assets.
Yeah.
Don't really care where ultimately they rest, as long as they don't rest in
Your hands.
in a certain person's hands.
My lord, exactly. I don't want to get too far ahead of myself because I'm going to address that very specifically when I come to compensation and SRM. But you see at least the shadow of the argument. That is essentially the nature of the argument. It's going to be that the SRM case provides, as it were, examples of a broader proposition. And the broader proposition is that the state is entitled to control things in this way, and that the references to the public interest in the, I think particularly paragraph 56 of Lord Justice Laws's judgment in SRM, is simply to identify species of public interest, not exhaustively to define them. This, of course, is not a case in which we are remotely seeking to foster the sort of aim that one had in James, that we have in Adriatic, that recently, where you're redistributing wealth in that broad sense. But it is nevertheless a public interest of a different kind, which is precisely of the kind that my lord has identified.
Again, forgive me if I set hairs running, and sometimes they're not helpful, in which case I'm not offended if somebody tells me, but don't set them running. Okay? But I'm aware, we don't tend to do it in this country, but I am aware that some countries around the world, New Zealand I think is one, have rules about whether foreign nationals can own property.
Yeah.
Because they have an aim, a social cohesion aim. They don't want society to become too fragmented.
Switzerland.
Is that right?
Switzerland. You have to have a Swiss national, or you used to have to have a Swiss national on the ticket.
Yeah. And so I think your argument amounts to this, that actually, although the means by which you may get to an end may include requiring someone to divest themselves of property, that when it's looked at not as a discrete part in isolation, but as part of what is going on as a matter of substance in reality overall, that actually what the state is doing is controlling the use of property.
Namely the shareholdings.
Exactly.
It's like a legislative control on the use of shares, the limits of your rights in relation to shares. And in that way, that was the similarity I was seeking to draw out. It doesn't depend upon enforcement or otherwise.
Yeah.
It depends upon the nature of the scheme. That's how we put it.
I see.
At this stage of the argument.
I see.
And I'll come back to the public interest in protecting national security and all of that. But can I sum up? We submit the three core principles, and they're all, as you will have appreciated, interlocking. They all rather merge one into the other, but just for the purpose of trying to make them clear, that's what we get. But as I say, UCOS does stand as quite an extreme example of that. One can explain it away as enforcement, but it is about shares, it is about the state controlling the use of shares or taking it away, albeit in enforcement proceedings. But here we submit that we've got a control of use scheme. The thing that is being, in effect, used in Strasbourg autonomous language are the shareholdings that people are allowed to hold. And there are very specific rules that allow the Secretary of State in the public interest to intervene, to impose the sort of controls that are necessary, and they include divestment. And of course we acknowledge, for the purpose of this argument, that if one simply focused on the shareholding of the shares themselves, you say, well, there we are, there's the shareholding, you're required to divest, that means you're required to get rid of it. That's the end of it. It must be a deprivation because it's gone. It doesn't make any difference if it goes to the state or a third party. We don't contend that. But we respectfully submit that starts, as it were, from almost the wrong end of the telescope. The perspective is too narrow. And that would be to render lots of these cases very difficult to explain. And it is at least consistent with the underlying thrust of principle that one sees in the case law to look at it that way. So I was going to make 4 short submissions on application of that to our particular context, to the extent that hasn't already been covered in the submissions I've already made. The first of them is that the scheme here is a general scheme for controlling shareholdings in the public interest in accordance with legislation that Parliament has considered necessary and appropriate for that purpose. it is just as much a general scheme of that kind as was the legislation governing Agossi and all the legislation governing the licensing cases, where in effect the conduct of the business itself depends for its existence on the continuation of the license. And again, one can multiply the license examples. They're normally wheeled out for the purpose of assessing whether legitimate expectation has been created by the previous grant of the license. Answer no, but they're equally relevant in this case, and there are any number of them of Hungarian tobacco sellers in stalls who are put out of business because the tobacco sales are banned. I think it was Vakoni in Hungary, but their trade tractory are a well-known example, and some of the ones that the Court of Appeal have cited. So that's the first thing and the critical thing to note. Second thing, focusing on the realities and substance of the matter and looking broadly at whether or not something of value remains and not simply focusing in on the form. The shares must of course be sold, but you will get the sale price in return, whatever that may be. So you are on no view, and not in this case, deprived of all value. That is therefore fundamentally unlike, as it were, the expropriation cases stricto sensu, in which the right is extinguished, not merely the legal right, but the value associated with the thing. The underlying value associated with the thing has gone as well. So when the state takes over the hotel and it gets destroyed or taken down or demolished or whatever it may be, you're left with nothing. That's what they're dealing with. Whereas when you've got a situation where all the value of the land or a very significant proportion of it has gone because of some change, planning provision is revoked or whatever it may be, you're left with something. Of course, as the owner, you're standing there saying, well, hang on a second, that's now worth £5, and yesterday it was worth 100. But that isn't enough. That's still control of use. So
you say that this is not like the paradigm case of compulsory purchase, of where you have to buy a house, to knock it down and build a motorway. Yeah. You say it's not like that.
Yeah.
Because in the analogy is not a good one, because the house still exists and somebody else owns it, and you've got the purchase.
And you've got some value, yeah. And one can test it by saying, I know you can test it the other way by saying, what if the value was zero on the forced sale? But if the value on the forced sale was exactly what you put into it, I mean, it's not, because and we accept that because that's why we're here. But if it was full value, then there you are. You switch the value around. You used to have a shareholder, now you've got cash. And that is relevant for the purpose of this analysis, because the cases in which there's deprivation, stricto sensu, of the other kind, and Newcos is an example. But there they took away the shares, albeit to meet a corresponding liability that the state said it was owed. But they took away the shares in circumstances that were about as controversial as one could muster. Right. Still control of use. And of course, perhaps the reason why Strasbourg isn't unduly fussed about all of this may be the underpinning for why the judge didn't feel necessary to decide it. Because if you take the interference as existing on a spectrum, these aren't, as it were, categorical differences with legal consequences. They are simply illustrations, and strong illustrations, no doubt. That's why it may be relevant to do the characterization, but they're simply illustrations of the seriousness of the interference. That's why you can have situations in which there is a control of use, but nevertheless there's held to be a requirement to compensate. That was the situation in Mott, as I recall. So that is the position, that's the second proposition. The third proposition are, in essence, all of the points that we make in the skeleton of paragraph 41 around the sale. True it is, of course, that the person is compelled to divest. Yes. And there is control in the sense that it's got to be done within a period of 9 months. You can't sell to someone who raises a national security concern of a similar kind. But those are features that are required in order for the control mechanism to be effective. You have to have an obligation to divest.
The point was made by Mr. Hickman about paragraph 41, subparagraph A. The appellants were at liberty to decide whether to sell. Understand that point. Wind down. Presumably, what does that mean? End the business.
My lord, yes. I think so. Wind down or otherwise divest themselves of. I'm not sure quite where that language comes from, because here we're dealing with sell.
What does otherwise divest mean? Well, it is the respondent submission.
Yes, I think here they were required to get rid of them, so that it was they were required to sell. That's right. There's no magic in that.
Yeah. It may not, I'm just wondering whether paragraph A is A, a good point, and B, even if it's a bad point, whether it matters.
I'm not sure it does, because we accept that they were required to sell.
Yeah.
I think it's dealing with the regime in its generality, maybe, and perhaps it's gone a bit specific.
All right.
So there may be that blurring, but they were required to sell.
I mean, it is true that they're free to decide to whom they wish to sell,
It is.
to an extent.
Well, within, of course, to an extent is both not to someone who creates a national security concern.
Exactly.
And also for sale.
But also, if the market delivers anyone, if only one purchaser is prepared to take it, and then only take it for a penny, then you may be in more, whether that's really election, well, who knows?
Well, my lord, that's the nature of the statutory scheme.
Yeah.
It's a function, as it were, of a compulsion to sell within a limited period.
Okay.
And of course, we don't quibble with the basic notion that there is a potential difference, and maybe a difference of some significance in terms of value between a forced sale and not a forced sale.
Yes.
These are features of the relevant legislative regime. This is what Parliament has decided.
Yeah.
And in a way, one can understand that, because if you're Parliament, you're sitting there saying, we want to control this shareholding to make jolly sure that people we don't like don't get hold of the national infrastructure.
Yeah.
How do we make that work? It is necessary to have an obligation to sell, and it's necessary that should have a time limit, and it's necessary that you shouldn't be allowed to sell to your next door mate who creates just as much of a security risk.
And that may go to 2 points of principle. One is that it may be said to reinforce your earlier submission that correctly analysed, this is actually a control of use case. Because that's what the state is actually interested in. It doesn't really care how you go about divesting yourself. The second point is that it's not like, for example, true redistribution, as in James, where the leasehold is transferred from the landlord to the tenant.
Yeah.
And it's not like classic nationalisation, where the airlines and the shipping companies were all brought into public ownership.
One can look at it in this way. These are concomitants of the effective enforcement of the regime that Parliament has considered necessary to control the shareholding in national security cases. It's fundamentally unlike those leaseholder, freeholder cases where the whole or a part of the aim is the broader one of social redistribution, so that the money deliberately flows towards the tenants or the leaseholders from the landlords. You know, all of the legislation that has gone to Strasbourg has been of that ilk in that context, and they're doing redistributive things, and they're doing that deliberately. This isn't of that kind. It's a different thing. This is about making and accepting the consequences of making the controlling of the shareholding to protect against national security risks effective. But I respectfully submit that the punchline of that, when we get back to it, is going to be that that is simply an example of a different species of public interest. It isn't a distinction in category terms for the purpose of any part of this analysis. It's simply a different public interest feature and drive. And my lord, we note, for what it is worth, that the money doesn't go to the state. This isn't about the state getting hold of it and saying, well, we'll have that, thank you very much, even as it was in UCOS, you'll recall, but that isn't the position here. The position here is that this is, you have to sell, you can sell to private parties, we're not interested in having the money or the shareholding, but you've got to divest. That's how we put the argument anyway. Yeah. And of course I accept that in some of the cases, particularly the early ones, James is a paradigm example, the court approached matters on the basis of that deprivation was the thing. But there's been a lot of case law, at least considering whether something is a control of use or a deprivation. The examples are built up, even if the particular lines of distinction in terms of principle haven't unduly clarified. One can see examples before on one side of the line or the other. That's the benefit, I respectfully submit, of the analysis of the Court of Appeal in BAT. They tried to discern from the examples potential distinctions of importance, recognising that this was a factorial exercise in the end rather than a straight line thing.
Right, so that was your third proposition.
That was my third.
Yep.
And finally, my fourth one was going to be the state doesn't get it, but that weaves into the third.
Thank you.
Can I then turn to compensation and its amount? And I wanted, really, I'm going to mention, I was about to say Ozymandian, but it isn't Ozymandian, it's Osmanyan. I'm going to come back to that, if I may, in a moment. But I wanted to go simply to two cases for the relevant principles, and I respectfully submit they're probably all you need. One of them is James, and the second one is SRM. So James first, if I may, because this paragraph in James is the paragraph that is that's become the mantra. It's repeatedly cited in all the Grand Chamber and other cases that have followed in relation to this. It's behind tab 20, I'm assuming bundle 2 of your authorities.
Volume 3.
Bundle 3, oh my goodness, right. Bundle 3, sorry. Bundle 3, paragraph 54, I want on page 995. And again, you'll remember the facts. I'm hoping I don't need to open the facts.
Give me paragraph.
Paragraph 54.
Thank you.
And you see where it sits in the Grand Chamber's analysis. Look at the bottom of page 994. The heading is compensation. The applicants also objected to the compensation terms under the legislation. Entitlement. So they're dealing with when do you get compensation. And the critical bit is the final sub-paragraph within 54. The court further accepts the Commission's conclusion as to the standard of compensation, the taking of property without payment of any amount, quote, reasonably related to its value.
Yep.
So that is that relative concept, reasonably related to its value. I know that was of particular interest to the court in the we had a division court hearing not very long ago. I suspect judgment might be imminent in front of Lord Justice Holgate and Lord Justice Foxton in relation to something similar to James, the new changing to the legislation dealing with enfranchisement of leaseholds and so on. So there may be some wisdom to come out of that, but they were particularly taken by that phrase in the hearing at least. Yeah. Reasonably related to its value would normally constitute a disproportionate interference which could not be considered justifiable under A1. A1 does not, however, guarantee a right to full compensation in all circumstances. Legitimate objectives of public interest, such as pursued in measures of economic reform or measures designed to achieve greater social justice, may call for less than reimbursement of the full market value, and so on. But particularly in the final sentence, the court's power of review is limited to ascertaining whether the choice of compensation terms falls outside the state's wide margin of appreciation. So that's lots of principles all bundled up together, but that's the paragraph that is repeatedly cited.
And you would emphasise, I think, that last sentence has nothing to do with national security and the wide margin of appreciation that there may be and is in national security contexts. What this is focusing on is whether there is a reasonable relationship between the payment and the value.
Yeah.
That on that question, in international law, the state is given a wide margin of appreciation.
You stand back. I mean, we get to it when you get. I'm going to take you to SRM in a moment, but you'll recall the way in which Lord Justice Law was analysed the thing. He said we've got three principles in play, and they're by and large the overarching principle that underpins the entirety of the convention, which is the balance between private rights and the general interests of the community. Then we've got the concept of proportionality, and then we've got margin of appreciation, which allows the state, in essence, a leeway when judging in any particular context of social engagement. It allows them in the sphere of compensation itself to make judgments about whether or not, and if so, what level of compensation should be paid in particular circumstances. And that is a matter into which the public interest feeds It isn't a restricted public interest, it is the public interest that is ultimately for the state and particularly Parliament to weigh. But you get all of those from that bit of James. So just to pull them out very quickly, even if you've got a deprivation, let's assume for the sake of argument this is a deprivation, which is an extremely serious control of use, with the dividing line between them being a bit ephemeral. Even if you've got a deprivation, the principle is not one of full compensation, i.e. full market value stripping out or ignoring the interference in question, anything of that kind. It's not full compensation as they put it. It's rather the payment of an amount reasonably related to the value of the property, a much more gentle and relative term, which allows for public interest considerations to play. That's the norm, and there's even flexibility within that, because that's only a normal principle. So even then, the public interest may lead you to say, we're not actually going to pay everything, the full value, however you choose to define that. And ultimately, it's for the state to decide how to weigh up all those matters and where to get to. And it's only if you fall outside that margin that the thing will be incompatible.
But a problem we have, or at least may have in this case, which no doubt you'll come to, is that we don't have very much in the way of explanation of why the Secretary of State decided, if that's what was decided, that no compensation should be paid. We don't quite see how considerations of national security came into that, or where within the margin of appreciation it was decided that this case fell. So when you get there, I appreciate you're still on principles. That's something in which
But you'll be interested.
everyone would welcome your help.
My Lord, yes, of course, I would seek to help in relation to that. Part of the answer is going to be it's a matter for the court to assess the proportionality rather than relying on misbehaving grounds, relying on the reasoning of the Secretary of State, although that may bear on the width of margin and so on.
It can work in that direction. It can sometimes help the respondent if they have.
If lots of consideration has been given to it.
Yeah,
My Lord, that's true.
And then the court is invited to give appropriate respect
Of course.
and
My
weight
Lord,
to that. But the fact that it hasn't been done, I mean, we had this classically in the prisoner voting case.
yes.
It was neither here nor there whether Parliament had, in 1870, in the Forfeiture Act, given much consideration to things. But the question is whether, as a matter of substantive law, it is proportionate or not.
Yeah. My Lord, yes to that. And when I get to it, I'm going to be focusing not merely on the margin that attaches to the Secretary of State, but the margin that attaches to Parliament. Because Parliament has not chosen to legislate for a scheme in which, as it were, the consequences of the forced sale that the legislation envisages are to be compensated.
Yeah, and but it has also legislated through Section 30.
It has, but there's a question about there's a question which perhaps you don't need to get into for reasons I'll come to, about whether or not you need to, whether or not that provision is actually a compensation provision at all.
I see.
In the sense of making provision for the payment of the difference, as it were, between that are created by forced sale. Okay. That difference in value. There's a real and serious question about whether it is designed for that purpose. So you may not need to get into that because it may not matter, because the position may be that that's all about varies, and even if Section 30 does not, as it were, permit that, if there was a requirement under A1B1 to pay compensations in a case like this, or to go beyond the legislative scheme and the Secretary of State to decide in their discretion to do so, if that was an A1P1 obligation, there'd be a duty under Section 6 of the HRA to do so.
Well, it may go a bit further. Because if one's looking at a statutory scheme which, as in James, provides for a level of compensation to apply across the board, and one's looking at the public interest justification for the legislation or the scheme as a whole, that's one thing. If, and that's why this point may matter, if you have a scheme in which Parliament has decreed that there should be an opportunity for compensation, and therefore compensation has to be addressed on a case-by-case basis, then does one not have to look at public interest considerations vis-à-vis the individual circumstances of the particular case, rather than just more generally by reference to what the legislation is hoping to achieve?
My Lord, I think I would accept that, one is inevitably taken down the road of looking at the circuits of the individual case here, because the position, when we get to it, I will submit, is that Parliament has legislated, and it has chosen not, as it were, to produce a provision in that legislation that says we recognise that the consequence of this will be a forced sale. It's to be expected that if you have a forced sale with a time limit on it and restrictions on who you can sell to because it can't be of NS concern and so on, if you have that sort of setup, that will very often lead to a difference between what might be called the forced sale value or the forced sale price and something you would have got had that not existed. And what Parliament has not done is to say, we think there needs to be a compensation scheme that will be set up in these ways and in this manner. So they haven't required the payment of compensation, one could put it at least at that point. My point about Section 30 was that even if Section 30 doesn't provide, as it were, that specific power itself, that doesn't terribly matter, because if this is driven by A1P1, there would be a positive duty under Section 6 of the HRA to do that, and that takes one back to the need to consider the individual case and to decide whether or not compensation should be done.
That would be a fortiori if Section 30 was intended.
It would.
To cover compensation in these
I totally get that. It would, but no more than that, is the way I put it.
I understand.
Yeah. And that was James. Can I go to SRM, which is behind tab 12, possibly bundle 2? My learned friend fairly incorrectly, I respectfully submit, started at paragraph 43 on page 816, so we're behind tab 12, page 816, a third of the way down, 3 principles established by the authorities. Do you see that? And really the relevant section runs from there through to the end of paragraph 56. And I don't need to remind you of the key features of this, because I've summarised them already. You'll see the 3 principles he identifies in paragraph 43. You'll see what he says about the first of them at paragraph 45. You'll see the limits on the second principle, that of proportionality, at paragraph 48. If you'll recall the echoes from paragraph 54 of James that I took you to. And then he turns to the margin of appreciation at paragraph 49. And in those days, which is why you can pretty much ignore paragraphs 57 and following, in those days there was a debate, as you will recall, some of you may recall, as to whether or not the idea of margin of appreciation, the international concept, did actually come into and play in domestic law. And we now know that it plainly does, or something that looks almost identical does. But margin of appreciation is picked up at 49. And then he analyses, in particular, the 2 cases. James, I don't go back to. We've already looked at the key paragraph, which is the 3rd subparagraph of 54, which starts at the bottom of page 818. And as my Lord has pointed out to me on a number of occasions now, and I accept, the position there was they were deliberately trying to favour the tenant. This was a kind of social adjustment case and context, as one sees from paragraph 56. Lithgow is of some interest, however, and you'll see that's picked up in paragraph 52 of Lord Justice Law's judgment. Can I invite you to cast an eye down down that. And perhaps particularly I'm interested in the quote from 121 of Lithgow. And it's really the point I was making. You need to be a bit careful with the paradigm case because the public interest can play in different ways in different contexts. And here they were rejecting the attempted analogue with the paradigm case. And they were saying, well, hang on a second, it's a bit more complicated in our situation because there you were dealing with a scheme of nationalisation. That's a bit more complex. So you've got to do something different and the margin may play in a different way in the context of that situation. You can't just say, well, if my house is next door to the motorway, all these things apply and why doesn't the same thing transfer over?
And this was classic, this is what the Labour government of 1977 did. It's classic old-fashioned nationalisation
Yes.
of the aircraft industry and the shipbuilding industry.
Yes.
And if one casts one mind back historically to what happened after the Second World War, presumably one of the reasons why the government embarked there and Parliament embarked on nationalising something like 1/3 of the economy was because it didn't necessarily want to be lumbered with the bill of having, because if you have to pay the private shareholders a huge amount of money, you'll never be able to achieve, or you may not be able to achieve. So I think that's the point they're making. That be careful about drawing the analogy with the paradigm example of the house knocked down to create a motorway.
I'm making two points. One of them is a very important one, which is that one.
Yeah.
And it says actually you've got a disincentivizing effect where you have to, society continues to have to bear the burden because it's too expensive to wade back over the river. That's one of them. The other one is be very careful of the paradigm example when you're dealing with something which is dealing with a public interest issue of greater complexity or of a different nature. Yes. That's the kind of principal bit in 121, but it's important for both of those reasons, I respectfully submit. And the court then follows that on. You will see Lord Justice Law specifically then cites the totality of the next paragraph in the shipbuilding case in Lithgow. I invite you just to read that, top of page 820.
There it does pose the test for the court in terms of unless that judgment was manifestly without reasonable foundation.
Yes.
Now, on your submission, this has got an old case now, is that the test that is to be applied?
My Lord, I'm not allowed to say to a court I don't really care, but
right.
In a way I don't really care because of subsequent Supreme Court authority.
Right.
You'll recall in particular Lord Reed in SC
Yes.
addressing this idea, and basically the thesis was and remains that the margin, the doctrine of manifestly without reasonable foundation is simply a description of the breadth of the margin. So I'm perfectly content not to get into that debate, which is a debate about language, it might be thought post-SC, but to rely upon the breadth of the margin that these cases exhibit is appropriate. So a wide margin will do for my purpose, and if you want to call that manifestly without reasonable foundation, so be it. But it was in part perhaps that phrase that led to all the dramas and confusion about courts having their judgments read as if they were applying a rationality standard in the context of convention rights. So I'm a bit wary of the concept, and one doesn't need to go there, I submit. It's wide margin, that will do for me, if that helps. Yeah. But the significance of this paragraph in 122 in Lithgow is, I respectfully submit, clear. They've got a big margin, and it's a margin that applies not just at the stage of setting up the scheme, when do you take away the shares, but it applies to what you do to address the consequences of the scheme you've set up. Here, in effect, forced sale versus sale in the open market.
Well, and in particular, the final sentence
Yes.
makes it clear that decisions regarding compensation.
Yeah. Exactly, and the passage just above the first hole punch, it would in the court's view be artificial in this respect to divorce the decision as to compensation terms from the actual decision to nationalise, since the factors influencing the latter will of necessity also influence the former. So it's that you get a margin at both stages, set up the scheme leading to the deprivation or the control of use or whatever it may be, and you get a margin in terms of the consequence of that and the compensation that might or might have to be paid. But also bear in mind when you're thinking about that some of the justifications for setting up the scheme in the first place, the protection of national security, may well play into the breadth of margin that is afforded in relation to the terms of compensation. And that isn't just, as it were, redistribution. It can be, as here, because as my lord put it to me, if nationalisation had to be paid out in absolutely full, then society would continue to have to bear the burden of propping up difficult businesses. One doesn't just have to go back to the 1977 Labour government for that prospect. One can come closer to home and more recent in time in relation to British Steel, for example. But the same sort of points might apply.
So to come back to my lord's
Yes.
paradigm example,
Yes.
of compulsory purchase of a house to build a railway, if either as a matter of general legislation or simply individual application, the policy was only to pay 70% of market value on the basis that that was all the government could afford if it was going to build all the railways it needed to build, that would be a legitimate public policy consideration which might justify not giving full compensation.
My lord, yes. It might be, the justification might be harder to run if it was 10%, but yes, is the answer of principle to my lord's question.
So your answer to my Lord Justice Mayall's question, which he put to Mr. Hickman, but do finances have anything to do with this, is yes, in theory.
My lord, yes, in theory they can. All features are taken in. And when I come to deal with Osmanyan, you will see that really the judge's analysis in relation to that is more about risk taking than it is about how rich you are. But we do know that in circumstances where the other side of the coin is in play, in other words, where the taking away of the property not merely takes away the property, but withdraws the means of subsistence because of the poverty of the people whose land has been taken away as a result of the measure. They're taken away not merely the property but the subsistence. That is treated as a relevant factor and was treated as a relevant factor there. And what that illustrates is that one of the things that one can take into account is the breadth of the shoulders. We don't place an enormous amount of weight on it, but if you can take into account poverty, you must be able to take into account the flip side, is the way I put that. But the point my lord put to me is the broader one, which is, would it be acceptable for the state in designing a compensation scheme to say, we're looking at the broad measure, if we have to set up a scheme under A1P1 in which the consequences of forced sale and a diminution of value that might be argued to flow from that have to be compensated, can one take into account, as it were, the disincentivizing effects of that? The answer to that is plainly yes, and plainly yes on the authority of Lithgow 122. That's how we put it. Then the Lord Justice Laws at 55 and 56 pulls the themes together. And again, just to cut to the chase in relation to that, we submit that the paragraphs that there seek to pull the principles together are far from being against us, are entirely helpful to us. And what my learned friend seeks to do is to extract, in essence, from paragraph 56, a principle that says that the examples that are given by Lord Justice Laws represent, in effect, an exhaustive description of the circumstances in which the public interest can play into the terms of compensation. He says alongside that, we're dealing with something micro. Well, we're not. We're dealing here with a legislative scheme that controls who can hold shares and when they can be required to divest in the public interest. paragraph 56, the core point is, paragraph 56 is not an exhaustive attempt to analyse the narrow circumstances in which those are the public interest considerations in play, but a positive endorsement consistently with the very, very clear statement of principle that we've just seen in 122 of Lithgow, cited above, that the public interest can be in play and can serve to reduce what the person receives when they're compelled to do something. I can put it at its broadest. So the correct reading of paragraph 56 is not that it's, as it were, a narrowing down of things where the very basic conception of it is social redistribution. The public interest in all its features can and does play into the analysis, including in creating the breadth of margin that is available to the state in deciding how to balance these interests. Particularly if, I may say, particularly if it is an inevitable part of the scheme that Parliament has chosen to enact, that there will be a forced sale if divestment is considered to be the only necessary and proportionate course to take. So those are the principles. Now, as I say, I respectfully submit they're probably the only two cases you need, although Osmanyan might stand as an example of the application of the principles in its very specific facts, but it comes with the usual health warning, which is that one needs to be jolly careful about, particularly in the Strasbourg case law, about moving from specific application to particular facts to extrapolate into general principles. The general principles are dealt with in the Grand Chamber decisions, Lithgow and James, and are correctly applied, I respectfully submit, by the Court of Appeal in SRM. So turning to the application of those principles, the present context involves a social and legislative question. How to protect the public interest in important areas from threats to national security created by, in effect, the ownership of companies and of the controlling shareholding in companies. So this scheme, we submit, is just as much focused on protecting the public interest and advancing a public interest, perhaps more so, and designing the scheme accordingly, the legislative scheme accordingly, for the protection of national security in our context, thereby protecting the public. Not forget that national security is just a moniker for that, as the nationalisations in Lithgow and in Northern Rock, in SRM. It's just a different context with different public interest features in play. So far as margin is concerned, the protection of the public interest in this way, with the necessary feature of that effective protection of the public interest and national security, namely in certain circumstances, when the judgment is that the national security threat is significant enough to require divestment. That is, to require a forced sale. And the protection of the public interest in that way brings with it margin. The margin is broad or wide, both, as we've seen, in relation to the question, when can there be such an interference? How do you set it up? What are the tests for that? Here there's no challenge to that. Indeed, the premise is that there is a threat to national security which is sufficiently strong to require remedy A. In other words, to require divestment, specific consideration having been given to whether less intrusive measures, i.e. remedy B, would be enough. Answer no.
But do you say it's inherent in that, in divestment, that there will always be an undervalue because there's a forced sale?
Well, then, my lord, I can't
that's right.
I can't go that far,
no,
for obvious reasons.
No, so it's not an inherent part of the scheme.
It's not an inherent part of the scheme.
That full value won't be. realised.
My lord, it isn't an inherent part of the scheme that
You
full
simply
value.
say that's a possibility which is contemplated.
An inherent part of the scheme is that you have forced sales
Yes.
if the national security threat is sufficient,
Yes.
and forced sales are at least likely, in quite a large number of cases, or at least in some cases, to lead to undervalue, or to lead to...
It's how many buyers there are and
It does.
how popular the
My lord,
product
of course
is.
I say. Of course I say.
Another, Sir James, another way of putting that point might be this, I suppose, that traditionally, as we've seen from one of the authorities that was shown to us this morning, I think the Richards case, traditionally, the law refers to the concept of fair market value, and there are various assumptions built into that analysis, one of which is that there is a willing buyer and a willing seller. I think what you're entitled to submit is that in this context, that clearly is not an appropriate analogy, simply because Parliament has created a scheme where necessarily there's
The thing is
forced
forced.
sale.
The thing is forced and forced within a time limit.
Yeah, and a time limit.
But you can have fair value with an unwilling seller.
My lord, you can. All of these things are possible, as we know. I mean, we've all come across sales of companies in different, more or less forced circumstances in which full value is obtained, in which there's a big deficit in terms of what you might have expected if the interference hadn't happened. That's really the way of looking at it. But it's at least in the contemplation of Parliament that there may well be a significant number of cases, put it as low as that, may well be a significant number of cases in which the element of forcing the sale, by the way, which is only required if the national security threat is sufficient to justify that, no other measure would do, which is the unchallenged assumption and premise here, that if you get to that place, significant number of cases may lead to less value than you would have got if you hadn't had the divestment order. That's why I say the margin starts here with Parliament. It has made no express provision, we submit, for a compensation scheme of this kind. Goes back to the debate I was having with Lord Justice Popplewell, so I'll take it quickly. On the contrary, the provisions in the legislation simply require the divestment in specified circumstances. The significance, of course, of that is that Parliament has not considered it appropriate, at the very least, to say, if there is, as a result of the forced element that we're providing for in this legislation, if there is a diminution in value, as against whatever other standard there might be, if the interference hadn't happened or whatever it may be, if the divestment order hadn't been made, there is a requirement that should be made up. That should be made good by the state. They've positively not done that. And it does take one to Section 30. Section 30, if you go back to the judgment itself, if you would, sorry to jump around a bit, but judgment paragraph 222, it's not entirely clear what Mrs. Justice Farbey made of all of this. Maybe she shouldn't be criticised for that. But you'll see the submission that was made by Mr. Phillips, accepted and was keen to stress. Not sure that's ever a nice thing to say about an advocate, but accepted and was keen to stress that there is a provision for assistance and not compensation. And we respectfully submit that that was an accurate submission. It isn't a compensation provision. It isn't a thing where Parliament is saying, well, if you have a forced sale, as we provided for, and there is a diminution in value as against the position that might have inured if there wasn't a forced sale, you should have a compensation scheme and it should be done in this way. You didn't have anything like that. You just have a broadly framed scheme which is designed, it appears, to provide assistance in certain circumstances in relation to the company. Now, one can argue, well, is that or is that not broad enough? And Mrs. Justice Farbey seemed to think it was broad enough to encompass at least a discretion to pay compensation. And again, I don't terribly mind if that's the court's conclusion. We respectfully submit it isn't really designed for that purpose. But it doesn't terribly matter for the reasons we explored earlier, which is that if that forced sale element does lead under A1P1 to the need for compensation, then the Secretary of State would be under a duty to pay it anyway. But Parliament hasn't provided for it, nor has it set its face against it, because it couldn't.
But leaving aside the compensation and vires question, do you submit that at the very least what Section 30 does contemplate is the possibility of providing financial assistance?
Yes.
And that is relevant, do you submit, as part of the overall package
My Lord, of course.
assessing whether within the margin of appreciation this is proportional?
Yes. Whether or not it specifically encompasses.
I mean, would you accept that, for example, if somebody could place evidence before the Secretary of State that the final order is going to cause real hardship to them, would you accept that this would Section 30 would enable the Secretary of State?
Well, it could do. One could have the argument. I'm not excluding that possibility.
Okay.
I accept the broad proposition that my Lord puts to me, which is Section 30, whatever its meaning, is in effect a help in terms of proportionality, because it provides for assistance in certain circumstances. The question whether it encompasses, as a matter of varies, a discretion to pay compensation, which in order to avoid getting into debates about the RAM doctrine, one might have to find in statute somewhere, doesn't terribly matter in my submission, because you can find statutory varies in the Human Rights Act itself if necessary.
But does it not slightly undermine your point that there's some significance in Parliament not having set up a scheme for compensation in every case? One can entirely understand why they might not want to go back to the bad actor kind of case.
Yes.
But if the scheme they've set up is every order for divestment must be looked at on a case-by-case basis with the possibility of compensation at a level to be decided, why is it relevant that they haven't set up a general scheme for compensation in every case?
Well, my Lord, because it appears at the very least that they've decided that it shouldn't be a requirement in that species of case where there is what might be called a diminution in value as a result of the forced element. That's the only significance. And the fact of the matter is that because of the Human Rights Act and because of the way in which A1B1 plays into the Human Rights Act and the duties that it creates, I couldn't submit anyway that Parliament has set its face against compensation in individual cases. So one can contrast the bad actor as against the person my Lord put to me, who is deeply financially distressed as a result of this, the equivalent of having their olive plantation taken away in Osmanian. So there is that possibility, but it is driven, I respectfully submit, by there being a requirement on particular facts to avoid excessive or unfair burden under A1P1, where it would be a matter of duty under the HRA. So we don't need terribly to worry about whether or not Parliament has acknowledged that compensation could be paid. It hasn't sought to derogate from Article 1 of Protocol 1 in this way. But what it has not done is to, as it were, get to a place where it says whenever you have that sort of diminution in value created by the forced sale, here's the compensation package that has to be put in place. That's all. So it's a relative point, as it were, rather than an absolute one. But I come back to the point that my Lord Justice Singh hopefully put to me, which is that whatever it means, the existence of Section 30 is of assistance in terms of Parliament's looking in the round and seeing what assistance might be necessary in particular circumstances if there were, for example, to be hardship. That is an assistance in terms of proportionality. I said the matter started with Parliament. Obviously, it doesn't finish with Parliament because the Secretary of State has a margin. And are they going to treat this as a hardship case in which compensation should be paid? It was evident that the Secretary of State decided not. The Secretary of State was obviously aware of the forced sale aspect and was specifically notified of the possibility that there would be what I call the diminution in value as a result of forced sale, because that was specifically drawn attention to in the ministerial submission that was put up, that there might be difficulties of that kind and thus a reduction in the value that might otherwise have been available to them on the forced sale. We've given you the reference to that in our skeleton. I don't know if it turned up again, but our skeleton at paragraph 47B. We've given you the reference into the supplemental bundle if you want to see that in the raw, but that's the reference you need. I wanted to make 5 short points. I've probably covered most of them, so I'll again try and take them as quickly as I may, but 5 short points headed no disproportion. first point is that we are dealing with people who are, and corporate entities controlled by people who are considered to raise sufficiently serious risks to national security that it is both necessary and proportionate to require them to divest. I started in my introductory submissions with the national security aspects and gave you various references into the judgment for that purpose. Can I also invite you to note in that respect our skeleton at paragraph 31. I don't go back to it, but there's a bit of riposting in that in relation to some of the ways in which my learned friend has sought to put what the national security case is there. So can I invite you to note that, as it were? And we submit that you can legitimately consider this fact as being relevant to the proportionality analysis and indeed to the compensation question. The distinction, as it were, the divide between the thing that justifies the measure that interferes and the compensation setup is porous. We saw that from 122 of Lithgow. And it is relevant, we submit, that we are dealing with a situation in which the people who might suffer this diminution in value if there is a forced sale are only in that position because they represent that sort of risk to national security.
But how does that feed through to justifying undercompensation without knowing what the particular circumstances are? There may be someone in the middle management of the Department of Merchant Marine in Moscow who, because of his financial circumstances, is particularly susceptible to being lent on by the Russian state authorities. And if he's the ultimate beneficial owner, he may be made the subject matter of or a company which he owns may be made the subject matter of a divestment order. But it doesn't follow from that it would be proportionate not to compensate.
Well, it doesn't necessarily follow from that it would be disproportionate or it would not be proportionate not to compensate. I don't say that it necessarily follows. I simply identify it as one of the relevant factors to take into account.
But what I'm questioning is whether it's a relevant factor put at the level of generality at which you put it. Because if as a factor it may in any given case support undercompensation or may not, how does relying on it just as a general factor help us?
Well, my lord, because these are threats to national security is the answer to that. And the person who's the middle management person in the Ministry of Merchant Marine or whatever it was who puts himself in that position has put himself in that position. The state is only in this place where it is requiring a forced sale in circumstances where the person's put themselves in a position that they represent a threat to national security. And that is not, I respectfully submit, likely to be characterised by the entirely innocent person in the Ministry of Merchant Marine, and isn't in this case, as we see from the fact that they've been sanctioned for various reasons in various different jurisdictions, and they are who they are. So even though I can accept the possibility, and of course I accept the possibility that if one puts it too high, as it were, the relevance diminishes the further you move towards innocent person as a category. I accept that, but I would respectfully submit that even in the case of the innocent person, there is still force in that idea. Parliament is legislating in the round.
We know from other cases that have concerned the sanctions regime,
Yes.
that not everyone who falls within the statutory definition is necessarily sanctioned. What we do know is that here there were 4 individuals who were sanctioned.
Yeah. Well, we do. We do. And again, I think I can accept, at least with a degree of equanimity, the point that my Lord Justice Popplewell puts, which is that these things may exist in a spectrum, and if you are entirely innocent or towards that end of the spectrum, it may have a great deal less force. But Parliament necessarily is legislating in general terms, And if you have put yourself into a position where there has to be divestment in order to protect you against that, and let's bear in mind that that's the premise for all of this. You're not dealing with less intrusive measures where, as it were, the cutout could be put in place. In order to get to remedy A here, you have to conclude that none of that is going to work, and the only thing that's going to work properly to protect national security is to require you to actually sell them.
Well, I understand that. Once we go to the particular and we talk about these individuals being sanctioned and so on, we're in a different territory from the general
You were putting to
proposition
me the
about
general
that one.
position, and whether I'd overstated the general, but I hope I've come a bit of a way towards my lord's proposition.
Is that your first point?
That's the first point. Just one final codicil to the first point, which is that my only friend Mr. Hickman says, well, this is not put and not evidence and all the rest of it. My submission is that it's not accurate on either front. You can see the way in which the submission was ultimately put below paragraph 228 of the judgment, tying in someone who acts in contrary to the interests of national security, whether they ought to be reimbursed and the effect that that has on the breadth of the margin. So you can see from that that it was taken below. It was taken in that way. And I respectfully submit it's not in truth a matter of evidence at all. This is a matter of working out how the scheme works, what are the fundamental levers that are required to be pulled in order for it to be in play, and those are features that are set out in the legislation, which after all is all to do, as its short and commencing title indicates, all to do with protecting the public against national security risks. So that's the first point about no disproportion. The second point is that on divestment, the shares at least can be sold to another private party.
Sorry to interrupt you, Sir.
Yes, I'm so sorry.
In fairness to Mr. Hickman, can I ask you please to finish by 4 o'clock?
My lord, of course you can, and I will be. Second one, on divestment, the shares can be sold to another private party. That is subject only to restrictions that are necessary to ensure and preserve the coherence of the public interest protection that lies at the heart of this scheme. In other words, you've got to sell. That isn't always mandated. But you've got to sell because it's necessary and proportionate. That's the test that has to be satisfied for that to be the only remedy that works to protect the public interest. And then you have to sell within a particular period subject to a legal obligation to do so. Otherwise, there wouldn't be any control over it, any enforcement mechanism. And by the way, you can't sell, and you only can't sell, to someone who creates an equivalent national security threat. And those are all concomitant and necessary features of the protection of the public interest that lies at the heart of the scheme. So we submit that that's second point is of relevance. The third point is that the market value is received on that sale in that way and can be retained. There is no case that we're aware of in which A1P1 has been held to require that the forced sale element be compensated.
When you say market value, you really mean market price?
Market price.
Or the value in that?
My lord, I do.
In that market?
I do.
Yep.
I mean, all of these things are shorthanded as they are in the case law, but I know they conceal a breadth of subtlety, but I use it in that way, the difference between forced sale and not. But no case says, well, actually, you must compensate that element, otherwise it's going to be unfair. The person's going to, however broad their shoulders, is going to receive that, and that must be compensated as a necessary concomitant to proportionality. No case comes close to that, and indeed, on the contrary, as we saw when we looked at the case law, the governing principle is not full compensation or market value or whatever, however you want to describe it, but reasonably related to value, allowing public interest balances to into the game, public interest balances to be struck, including in relation to the design of the scheme of compensation, margin and so on, even if you might get considerably less than what might be described as full compensation or full market value. See James, see Lithgow, see SRM itself. All of those cases allow for that. And Osmannian, we respectfully submit, is not the sort of case that my learned friend needs. It had the very particular features that you saw, and what you can't do is to reason from particular outcomes on particular facts to some species of general proposition. Indeed, the critical point, it might be thought about Osmannian, is the one I've already made, which is at the flip side of taking into account the fact that the olive groves disappeared and the vegetable garden disappeared, so the means of subsistence disappeared, it is that it is at least relevant in this exercise of seeing whether an individual person has borne an unfair or excessive burden, to have regard to the fact that the person is not being put, as it were, on the poverty line as a result of the measure that the state has taken in the protection of the public interest. So there is no case of that ilk, and I respectfully submit that all the indications are that Strasbourg would not go there. At the very least we submit, and we don't need to go here, but you're well aware of the principle in AB and the Secretary of State for Justice, the redefined Ulla principle. You can't be fully confident that Strasbourg would go to anything like that place of saying if you end up in a situation in which you're forced to sell shares for these sorts of reasons, and there is a diminution in value as a result of the forced sale element, that has to be compensated as a necessary concomitant of proportionality. That's the third point. Yep. The fourth point is that these are people who not merely pose risks to national security in the present context, as is in this appeal unchallenged, but they are also sophisticated commercial people who were on notice of the possibility that there might be intervention of the kind that ultimately ensued. And we respectfully submit that the judge was entirely right to place significant reliance upon that. They are not, like some of the applicants in the European Court of Human Rights cases, people whose livelihood has been destroyed or would be destroyed. They are large-scale investors who can well be taken to appreciate both generally that they might lose money on investments if they invest into industries or technologies or companies which are critical to national infrastructure and therefore raise in principle the possibility of those sort of national security concerns. So we submit that that is a relevant feature. And the judge was right to conclude at 225 that this is part of the, as you put it, the economic landscape for those operating in the altnet sector or other parts of the national infrastructure. And not merely that as a matter of generality, but it's perfectly obvious that these people did anticipate that the thing might be called in when the NSIA came into force. That's why I went through at the very outset of my submission the timing points that I made. They sought, we respectfully agree with Lord Justice Mayles on this, they sought to meet the Bay's official, didn't ultimately secure the comfort they were looking for. They sought to engage with the Bay's official precisely because they realised that they might be subject to that. And when one looks at the timings, that becomes entirely clear. That's why Parliament puts in the anti-avoidance provision in section 2.4. And as I say, there's a perfectly sensible and powerful case that can be made that says, well, even after they realised that was coming in, what they did then was to acquire the company for £100. They then chose to invest whatever money they invested in the meantime, whilst the Act was going through Parliament. That is an assumption of risk that they chose to undertake. And it is essentially that feature that they say they've lost as a result of the forced sale, that they say is a necessary concomitant of proportionality, that they should be compensated or reimbursed for that value. And so for all of those reasons, we submit that that is the critical feature. It doesn't terribly matter whether there is, as Melanie Friend kept putting it, a degree of retrospectivity in the Act. There is to that extent in section 2.4, but the key thing is about appreciation of risk. So far as procedure is concerned...
just before we get
yes,
to
my Lord,
is it a factor at this stage of the argument that the exercise of identifying the diminution in value due to the forced sale element could be, probably would be, a very difficult exercise? I was looking at the disposal plan that we were provided with this morning,
Yes.
and it makes the point that there are all sorts of economic factors prevailing: unfavourable market conditions, recession in the UK, high interest rates and inflation, drop in technology sector valuations, debt markets near close for this sector, recent failed or struggling transactions in the UK fibre market. That's paragraph 3.4e. And the valuation exercise would have to separate all those out somehow in order to arrive at a diminution in value figure. What I'm wondering is whether that is a factor which goes to the margin of appreciation as to whether there should be a compensation scheme for this element, or whether it is simply a problem which, if there has to be, would be grappled with at that later stage.
My submission is that it can be taken into account. What you're seeing from that document that it leads to is a valuation that runs between 30 and 200 million, which rather emphasises the point as an indicative value.
Well, that's said to be, I think, even before you take the diminution factor into account.
Yeah.
Yes.
But I respectfully agree with my lord. That is, I say agree. My submission is that that is a relevant factor to take into account, and it also, particularly when one contrasts it with, for example, the nationalisation of Northern Rock, it rather emphasises the point that I was making about what Parliament chose to do, as it were, because very often when you are having to deal with tricky issues of compensation and value, Parliament legislates to provide the parameters within which that occurs. That was specifically done in Northern Rock. It was specifically done in Lithgow. Indeed, that was the target of the complaint. They've set it up on a basis that favours the state. But so it does feature, I respectfully submit, in all of those areas. Can I conclude, if I may, on this exercise by just emphasising 2 or 3 tiny points at the end? Their value, the reference in the judgment to their value, it's the valuation they put on it. It isn't our case that that's the moniker, for obvious reasons. But we respectfully agree with my lord that at this level, the court needs the right answer. But we're not seeking to hang anything of significance on that. Secondly, expropriation only where the state gets it. Again, no interest on our side in that. There are certain circumstances where that's compelled. Broad shoulders, we do disagree. We respectfully submit that's the concomitant of Mannion. And if you get to remedy, you reach that stage in the judgment, you're looking at what you should do in terms of disposal. We respectfully agree with Mr. Hickman. There hasn't actually been any argument by anyone, still less before you, as to what the right approach would be. The position in relation to how this case comes before you is that the government has, in effect, taken its stand in this case on the basis that they get what they get. And that's it. So if you get into saying, well, that's not enough, you need more, you need something that looks a bit like full compensation or fair value, whatever you choose to say, then precisely what that means will need to be argued about both in principle and on the facts. So the correct remedy would be remittal to whatever forum.
And
So those are my solutions.
would that be remittal to the King's Bench Division, or do you not mind?
Yeah, I don't really mind. It probably ought to be remittal to a court that is used to both trying to work out what the right answer is on the facts, but also has an idea about the convention.
I stress that what I'm saying is not based even on a provisional view of what the outcome of this appeal will be.
I suspect it would be King's Bench then, probably.
Well, I was going to say, if we reached the remedy stage,
that point, we can make submissions in relation to the draft.
It might be. See, what often happens in the administrative court is that issues of principle are adjudicated on in the administrative court.
Yes.
But any issues of quantification are then transferred to the King's Bench Division.
Yes.
That might be the logical dividing line.
Well, one could do it that way, or you just simply remit it to the King's Bench Division and make sure that the judge who sits on it
well, that's another way of solving the problem.
is entirely appropriate for the case.
Business and Property Court.
Yes,
Yes,
exactly.
That's an option as well. Those are my submissions.
Can I just check if there are any other questions?
Could I just raise one thing?
Yes.
In relation to the sanctioning, would it be possible to provide us with the sanctioning documents, the EU sanction documents and the domestic ones, which identify the grounds for the sanctioning of was it 2 remaining individuals by the time the order was made?
Yeah, yes, we can certainly think about that, my lord. If there's a drama in terms of confidentiality or whatever, we can shout, but we can certainly see what we can
perhaps
do.
you can discuss that with Mr. Hickman.
Yes, of course.
Thank you.
Can I just, before you sit down, forgive me, can I just clear one thing out of the way? Because no one has mentioned it. And again, I don't want to set a hair running.
Right.
But in the light of the recent decision of the Supreme Court in Schwidler about what the role of an appellate court is, can I take it that you, for your part, would be content if this court, although it is the Court of Appeal, not the first instance court, if we do the proportionality exercise. No, we haven't had any submissions. We've seen nothing.
On whether the test is the wrong test or whether it's
Yeah. In this context, given that there hasn't been any previous decision at the appellate level about this scheme.
My Lord, can you take it that my answer to that question is yes, I am content?
Yes.
Unless something very dramatic happens in the next 10 minutes.
Yes.
But I see the force of that. It's the first of its kind.
No one suggested that we shouldn't do it for ourselves.
No.
And I don't want to set that hair running.
No.
I've been there before.
No. I mean, it may not matter much anyway here because the wrong test would take you into the arguments of principle that we've effectively been having with the facts as they are.
Thank you very much.
But yes, take it as yes unless someone shouts.
Thank
you, my Lord. Can I just begin by taking just a little bit of a step back? In this case, we did get something, as my learned friend has emphasised, we got the sale price.
I'm sorry,
We got the sale price.
Yeah.
Sale price. Yeah. If it was inconsistent with the statutory scheme, because we are national security problems, to receive money, we wouldn't have been allowed to keep the sale price. But of course we were. How much we received was entirely unknown at the time the final order was made. It was an arbitrary figure. And in my submission, the central issue here is that there needed to be an independent way of ensuring that we were fully compensated. And although my learned friend has urged you, as it were, to reconstruct a decision that in this particular context it is not necessary or proportionate to give people who've been divested of their assets full compensation. And in doing so, he's appealed to a wide margin of appreciation. The problem is, there is no decision to that effect which you're being asked to endorse. It wasn't a decision taken by Parliament. It wasn't a decision taken by the Secretary of State. And there isn't even any case advanced as to why it would be inconsistent with the policy underlying the Act for us to obtain compensation. Can I just very briefly show you the pleaded case on this, which I mentioned? It's in Core Bundle 196. This is the response to our Ground 1B. Very short. 70L on page 196. The claimant's assertion they're entitled to compensation is wrong. The final order required the sale of up and therefore did not amount to a deprivation without compensation. In any event, A1 does not provide a right to compensation. I've heard some legal principles. So there's no positive case that there is a policy that would be undermined in any way if we obtain compensation. And it can't be, because we did obtain the sale price. The point is that the sale price was an arbitrary figure that doesn't necessarily correlate to the loss. And you've been taken to no evidence which fills that gap. There's no evidence in these appeal bundles on the issue, because there is none. You can be sure if there was, you would have been shown it. So that's the bigger picture. Is it a deprivation or a controlled abuse? So points in reply. My learned friend says, first of all, there's a scheme of control. But unlike the cases such as the gold case about the German gold, this is not a case where there are rules that have been breached and are being enforced. Okay, there are no rules here that have been breached. There are certain trigger criteria which can trigger a discretion on the part of the Secretary of State, who will take a decision partly based on information which is secret. And can I just refer you back to section 26, which we just looked at in passing of the Act, which is in tab 2, and section 26.3, the Secretary of State may, during the assessment period, make a final order if the Secretary of State is satisfied that a trigger event has taken place and he reasonably considers that the provisions of the order are necessary and proportionate for the purpose of preventing, remedying and mitigating that risk. So it's a very broad general discretion. It is quite unlike a tax rule or a rule that prohibits imports of certain goods into the country and which is subsequently enforced by taking those away. So to try and shoehorn this situation into that line of cases, in my submission, is quite wrong as a matter of principle. In any event, the point doesn't work in our situation because the statute was not in effect at the time when the acquisition occurred. So even if you could apply that line of reasoning, as it were, going forward to people who are governed by the Act as a matter of law, then it can't apply to us. And of course, those who are governed by the Act have a whole system of notification, voluntary, mandatory, which didn't apply to us. So in my submission, the scheme of control argument simply doesn't work. Then my own friend says, well, you do get something here. And because you get something, it's more like a control of use. You get some money back. You're not having everything taken away. That clearly doesn't work as a submission. Numerous cases where there's been a deprivation are situations where there's been some compensation. James against the UK. People who enfranchised had to pay an enfranchisement premium to the landlord. So the landlord obtained quite a lot. SRM. People who had their shares taken away were subject to a compensation regime under the Act, as I've shown you. Essen, Sweden. One neighbour having to transfer their property to another neighbour. They obtained monetary compensation. The case about the olive grove, again, same, they obtained some compensation in that context, in private law proceedings. Bistinis, all of these cases, they got some money. They're all deprivation cases. It would completely undermine the concept of a deprivation if it ceased to be a deprivation just because when the property was taken you received some money back. If it's a deprivation, you normally should get full compensation. It ceases to be a deprivation just because you've obtained some compensation. The entire scheme of Article 1 of the First Protocol would fall apart. Then there was submissions along the lines that the deprivation in this case was of an asset that the government was not particularly interested in, just wanted to move it out of the hands of my clients. But again, you can say the same in a number of cases, Essen, Sweden, the Olive Grove case, and why not the Northern Rock case, SRM? What was the reason there for the deprivation of the shares? It was the wider risk to the public presented by uncertainty in the financial system. Government wasn't interested in the particular shares. That was the whole point. It was a risk to the financial system that it was trying to protect against. Here there's a risk, it's a different type of national security risk, it's not an economic one here, it's a geopolitical one, but it's the same concept. Okay? So it's, in my submission, none of those submissions have any traction. So clearly a deprivation. Principle of full compensation applies. In my submission, the SRM case sets out the correct principle. I've made my submissions on that. We accept that when looking at how much a company or a person should obtain when there's a deprivation, a margin of appreciation can be applied. So to that extent, there's nothing between my own friend and me. But only if there is a policy that is inconsistent with full compensation. And that's very clearly what Lord Justice Laws held in paragraph 56. I took you to that at the end of the paragraph. Where there's a policy that is inconsistent with or would be undermined by providing full compensation, then it's a matter for the state to decide, well, how are we going to compensate here? Where shall we set the limits? And then you have a margin. And if that's what the government had done in this case, then there would be a margin. The government here had some positive case that there was a policy that was inconsistent with providing compensation to my clients. Then the government had then said, well, in which case we're going to set compensation at this level, or we're going to give it to these people and not that people. Then this court would afford a wide margin. But it doesn't have any of those things. So there's nothing to afford a margin to. It said Parliament has taken a judgment, but Parliament hasn't said anything. Insofar as it has, Section 30 indicates that it can provide compensation on the specific facts of specific cases, and on the specific facts of our case, no consideration was given to compensation. And insofar as there's suggestions, oh, well, Section 30 might not apply, there's no pleaded case to that effect at all. In fact, my learned friend positively relies on Section 30 and our request under Section 30, although he hasn't run it orally today, but it's featured in the past that we requested compensation under Section 30. Even if my learned friend can say, well, there's nothing positive in the Act that says people should get compensation in certain circumstances, it's important to note, first of all, that divestment is not intended to be the primary remedy under the Act. Final orders will generally go much less far than divestment. Divestment is unusual and very much a last resort. And secondly, there's a notification regime. So Parliament will obviously understand that, save in that small window of retrospectivity, everyone is going to be expected to either notify because they're required to, or voluntarily notify. So in my submission, one can't really place any weight on that. Lithgow, this was a general scheme of nationalisation, and the basic point that was being made there it was that while there was compensation provided, it wasn't possible, given the wide-scale nature of the measure, to have a very individually tailored compensation. And it was said, well, here there is a policy, we're being presented with a policy and an explanation for why it would be inconsistent to compensate everybody fully, and we can give a margin of appreciation to that. But there's, as I said, there's no such policy advanced in this case, and it's equally not a case where it said that there would be similar analogous difficulties, because here, obviously, divestment decisions are very specific to individual companies, like my clients. It's not a general measure of nationalisation. There'd be no difficulty at all, although my Lord Justice Mayles raised a point at the very end about, well, will it be complicated? Well, it won't be as complicated as trying to calculate compensation for a nationalisation regime. And of course, it will be complicated to the point that you would need expert evidence, no doubt, to assist in the quantification of the value of the company. But in my submission, it's no more complicated than many of the matters that the commercial court, business courts, have to deal with routinely. My learned friend made the point, he said that the regime is dealing with people who put themselves in a position where they pose risk to national security. Now, he was ambiguous in his submissions whether he was directing that submission at my client or whether he was directing them at the UBOs. But the risk that was identified related to the UBOs. It did not relate to my clients or any position that my clients have placed themselves in.
That's certainly how I've understood what this case is about.
I'm grateful. In relation to the UBOs, we will certainly provide there's no difficulty providing the sanction documents we refer to them in paragraph 7 of our skeleton argument. And the point we make there is the basis for the sanctions, that's the sanction regime against Russia, is that it identifies certain people or entities that if they are subject to severe restrictions, that might put pressure on the Russian state. So it's not said that they themselves have been complicit in the invasion of Ukraine or anything like that. It's simply an instrumental way of trying to put pressure.
And I think there are different criteria, so that's why I quite like to see the documents in this case.
Yes, well, we'll hand them to you, but we've quoted them in paragraph 7 of the skeleton argument. Corporate controls, my learned friend said that it was untenable to be arguing that corporate controls could mitigate the sort of national security risks in this case. I don't think anything really turns on it on this appeal, but you will appreciate from the judgment that it was the Secretary of State that proposed the corporate controls. The Secretary of State put forward various options for putting barriers between us and my clients that we contributed to. So that was proposed as a possible way forward short of divestment. Closed material procedure. I hope that we won't hear any more on closed material procedure, as it were. But the decision was made by my learned friend not to rely on closed material on this appeal. My submission, it would be fundamentally wrong for this court to rely on any impression that it may have as to what might be within the closed material in the absence of any closed hearing before this court. And there's no indication, whilst I quite accept what my learned friend said, that the judge did rely to some limited extent on closed material in the national security part of her reasoning, there's no indication at all in the judgment that she relied on any closed material in relation to this A1P1 issue. Manifestly without reasonable foundation. I've handed up the case. My learned friend said there's been subsequent cases. I'll look at the case that he's referring to, but I think the subsequent cases are just about margin. I don't think they affect the principle that manifestly without reasonable foundation is not the correct test. But in any event, the point I'm making, and I've made before, is that since there is no decision here, which you're being asked to, as it were, review, not to provide compensation, there's no purchase in any event for such a test. My lords, unless there's anything else, those are my
That's very helpful, Mr. Hickman. May I check if there are any other questions? Thank you all very much indeed, and I include not only the advocates from whom we've heard, but also other counsel and solicitors. We will reserve our judgments, and they will be circulated in the usual way on an embargoed basis. Can I stress, as this court has done in recent years, that those drafts are provided on a confidential basis for very limited purposes, principally for typos and obvious factual errors to be corrected. And we would hope that an order could be agreed in writing without the need for a further hearing. If there are other consequential applications, and if further time is required after judgment is handed down, then we will consider that. But I would be hopeful that, as normally happens, everything can be wrapped up by the time the judgment is handed down. Thank you very much.